You may have found yourself receiving a refusal of a visa application from a delegate of the Minister of Immigration. This usually leads to a review application lodged with the Administrative Appeals Tribunal. Should it eventuate that the tribunal upholds the decision of the delegate of the Minister of Immigration, you'll find yourself normally with two options. First, leaving Australia, or appealing the same to the Federal Circuit and Family Court of Australia. The Federal Circuit and Family Court was formerly known as the Federal Circuit Court of Australia. What is the Federal Circuit and Family Court of Australia? The jurisdiction of the Federal Circuit and Family Court is best described in terms of three main areas: family law, migration law, and some other areas of general federal law, administrative law, admiralty law, bankruptcy, consumer law, human rights, industrial law, intellectual property, and privacy. Today's topic is about migration appeals to the Federal Circuit and Family Court of Australia. There are usually three major reasons or grounds one can be successful with an appeal to the Federal Circuit and Family Court of Australia. There are, of course, others. The first is where there is a denial of natural justice. This stems from Section 357A of the Migration Act. Essentially, this means that the tribunal has not been fair and just. The second is where a written decision is received from the tribunal and the reasoning provided is insufficient or not in sufficient detail to allow a losing party to understand why they lost or there was an incorrect interpretation and application of the relevant law. We will examine the third reason as found in the leading case of Minister for Immigration and Citizenship versus Lee, which is LI, which was decided by the High Court in 2013. This centers around the question of whether the decision maker has been unreasonable in arriving at their decision. The definition of what is unreasonable is sometimes difficult to explain. It is probably best for today's purposes to simply accept the natural meaning of what is unreasonableness. The Lee case was the first occasion where the High Court of Australia, which is the highest court in Australia, defined and expanded the meaning of reasonableness in relation to what is known as jurisdictional error in migration cases. As opposed to being exhaustive and long about what transpired in this case, what is important to understand is that the decision must be rational, logical, and reasonable. Should there be a failure of one of these three, then there's a good chance that you will be successful with your appeal. No doubt, it is not so simple to win matters at the Federal Circuit and Family Court, and it can be a very expensive exercise. What is most important is get the right team to act for you so that you have the right and best chance of success in legal proceedings. Stephens Tozer has the experience and expertise in appealing decisions made at the Administrative Appeals Tribunal to the Federal Circuit and Family Court of Australia. Today, whilst our focus has been on appeals, the best forum to be successful is at the AAT review. And for that, we ask you to watch our previous video. This will no doubt save you a lot of money if you are successful. If you need assistance and representation before an Administrative Appeals Tribunal and the Federal Circuit and Family Court, please don't hesitate to contact our practice, and we will see that your situation is assessed promptly and comprehensively. Thank you for listening.